As the panel comes up, you'll notice that the first problem and vision has been put onto the screen. The panelists, I will quickly introduce them by name. Lynn Chard. Lynn, if you want to sit up here. Angela Tripp. Chris Hastings. The Honorable Cynthia Stevens from the Michigan Court of Appeals. And Maya Watson is a member of this panel, but Maya's currently stuck in traffic, so when she arrives, we're going to have her join us and sit down up front. I'm not going to waste a lot of time. I hate going to presentations and have people read PowerPoints to me, so I'm not going to do that. I'm going to assume that everybody in this room and everybody who's watching virtually can read the slide, and we're going to move right into the discussion. And I'll start off with Lynn. This first issue is what's been described as a dysfunctional legal marketplace. How would you describe that? How would you characterize it? Some of the dysfunction that you see within the legal system and what accounts for it?
Well, in summary, it's you have a very significant unserved or underserved legal marketplace, people who want legal services, some of whom cannot afford them at all. Others are willing to pay for legal services, but not at the rate or for the style of legal services that the marketplace and traditional lawyers and the traditional hourly fee is providing to them. So it's a big unserved market. And when that happens, and it has happened many times in the last few decades in many professions and industries, you have disruptive innovation. You have upstarts who start to find a different way to serve those needs. And I think in our marketplace, LegalZoom is an example of that. In the business field, they can go through example after example where successful new businesses have challenged the old, the standard providers, and have been successful because there's a big underserved market. And they simply approach, their business model and their approach is totally and completely different. And that's kind of what's happening in the legal marketplace now, or at least the factors are very ripe for it. And so I think that this task force is trying to acknowledge that and think about how is it likely to change. An example of how the disruption happens is with LegalZoom, they start with a lower end product, a sample form for a very low price, but not very long goes by, and then pretty soon you start seeing that they're offering more legal services. You can subscribe and get actual individual counseling from a lawyer. So they eat into the marketplace from the bottom up, but with a totally different business model and approach. And usually, very, very often, technology is at the core of this too. That's what enables it. It's not just the idea of doing it differently. They can actually do it. And they are. And so we're in a profession that's regulated, that has, we're all traditional legal providers and lawyers, and we have ground rules. And we're at a disadvantage to compete in those new ways unless we start to look at them seriously and start to think about what is it really going to look like. And I think in this particular panel, for years, we've been trying to find ways to better serve low-income citizens, individuals who simply could not afford legal services. But the problem is a much broader one now. It's that plus the middle class. So that's, okay. And then lawyers, on the other hand, we have lots of lawyers and they're underemployed. So the market is underserved and the lawyers are underemployed. That's the crux of the problem.
One of the things that Lynn described is the unmet legal needs. And recently the Conference of Chief Justices and the Conference of State Court Administrators came out and they published a report that has this goal, which I believe everybody in the room shares, of getting 100% coverage of legal needs. Angela Tripp runs the Michigan Legal Help website. Angela, what are we doing in Michigan to try and reach that goal?
Thanks, Bruce. Is this mic on? Okay, thanks, Bruce. I was very excited by the 100% access decision and the publicity it's been getting, because it's something that we all believe in but has never been articulated as a very specific goal. In Michigan, one of the ways that we're trying to achieve 100% access is to look at civil legal needs and all legal needs on a continuum. On one end, someone gets zero help, they get nothing. On the other end, they have full representation for all aspects of their case. And we tend to think about those as the only options. But when you recognize there's a continuum, there are many levels in between where we can use resources and address the needs of people who may not be able to obtain or pay for full legal representation. And so we use resources like Michigan Legal Help as a step on the continuum that can be combined with legal advice from an attorney, that can be combined with help from a lay navigator, that can be combined with assistance from a pro bono attorney to get people, to get everyone some kind of assistance. And the goal is to get everyone to the right place along that continuum to get the appropriate level of service given their needs and their available resources. And one way that we're trying to do that, the 21st Century Practice Task Force discussed creating a triage portal that will be available online and that anyone can access, either individuals needing assistance or advocates working with individuals, and using expert systems logic trees. The system can help guide them through a series of questions and point them to that place along the continuum where they can best be served.
Expert systems logic trees. That explains why we have so many people on this task force bringing expertise that if you asked me about what an expert system logic tree was, I would have no clue, but Angela deals with it every day. You were talking about this triage system. What role do the legal help centers that we've got around the state play in that triage system? Do they play a role?
They absolutely do. They're one of the stops on the continuum where people can be directed. And the continuum takes advantage of all sorts of existing resources, such as Michigan Legal Help, such as self-help centers around the state, such as pro bono attorneys, such as private attorneys and legal services attorneys, and systems like ZeekBeak. And it takes all those systems into account, and with those resources creates the different stops along the continuum.
Now, when we first started rolling out these legal help centers around the state, I know in Grand Rapids, when we rolled out ours, there was a lot of concern by the legal practitioners about why are you doing this? You know, you're taking jobs away from attorneys, you're steering people away. And one thing we discovered in that process was so many of the people who came into the legal help center really didn't need legal help. They needed direction to a social service agency or something like that that might help them. That's not really a question, that's just an observation from the co-chair. But I'll throw it over to Cynthia. One of the things that has been mentioned along this continuum is from somebody who starts out having absolutely no access to somebody who can pay for everything to get the best legal representation to take the project from start to finish. There's this term that's thrown around called unbundling. Can you explain briefly what unbundling is and how that figures into this system?
Well, it's pretty much like your Comcast. Do you really need a high-speed internet, voicemail, and television? All 400 channels that are showing the same bad movie? In approaching a legal problem, the ultimate goal is to get a solution that works for the person with the problem, not the one that is most efficacious for the system. So if we have unbundling, we can have an individual who enters perhaps through a self-help portal, and they move forward to a certain point in a situation where they realize that they're actually going to have to sue the person who fixed their car. Well, the car is only worth $2,000, but it's their car, and they need it for work, so it's an important issue for them. What they need is to be able to get some money to fix the car so they can go to work to keep their family intact. In an unbundled situation, they could go to an individual who's legally trained, who's licensed. That individual could write the claim for them and tell them to go ahead and appear, because we know in many cases the parties are going to agree or the parties will not show up, at which point they didn't need you to stand there as an expert commercial litigator and facilitate this problem. So to unbundle would be to allow an individual to get access to legal services from a lawyer to the extent that they are needed. As things stand now, when a lawyer files a complaint, she's in that case until the court allows her to leave that case, and they have to seek permission. And that makes lawyers reticent to take in a matter where they know the person is of limited means, and maybe they could give them $150 to do an interview and to draft a complaint, but they simply can't afford the increased time to go into court to seek leave to be removed, et cetera. So it would allow lawyers to give low-cost legal services. It'll also make it easier for practitioners who are very busy to provide pro bono services, because they can come into the case at a certain point in time, perhaps triage the case as was discussed, perhaps later in the case do the collections. We've got a judgment against bad garage store X. Well, how do we get the money? I don't know. So the lawyer could perhaps help them fill out the garnishment papers and do that portion. But it would meet the need where the need is, afford the lawyer to provide the amount of time that she or he can afford to the situation, and address some of the unmet legal need.
Another question that comes up along that same continuum is when you have this triage system and you may get involved dealing with people who aren't necessarily licensed as lawyers, and yet they are providing what to some appears to be legal advice. Chris, I know you were involved for almost a decade in a process that dealt with the definition of what is the practice of law. Can you explain what happened there and why we're, as part of this task force, revisiting that whole issue?
Actually, it's been about 15 years, Bruce, and I was ready to put it away. I've served on the Unauthorized Practice of Law Committee for many years, and the idea started there, didn't get traction there. Eventually, it did get traction. We proposed a definition. The Representative Assembly voted it up overwhelmingly, and it failed to gain traction in the Supreme Court. As we started having this access and affordability conversation, we realized that we needed a common language. You know, I'm going to piggyback on Angela's comments a little bit. The legal practice of the 21st century, or the law market rather, that's the right term, for the 21st century will include lawyers. It will include legal resource centers staffed by non-lawyers. It will include websites. It will include lay navigators and computerized triage. And it will also include a number of unsavory folk who are preying on Michigan consumers. And in order to navigate that universe, we need a common language. And we need to know what the unauthorized practice of law is and what it isn't. And as lawyers, we generally know that. You know, individual lawyers in this room may have never studied it, but I could give you a stack of 6 Supreme Court opinions and tell you to take them home and read them, and you would know what the unauthorized practice of law is. But trying to convince somebody who's engaged in the unauthorized practice of law that they're breaking the law with 6 common law opinions is a dog's lunch. So the idea of codifying a definition of the practice of law allows us to have a common language that we can communicate easily in.
As it relates to the licensure, one of the hot button topics around the country now is whether it's called legal or limited legal law what is it? Triple LTs.
Triple LTs, limited legal license technicians.
And sometimes they call them triple LPs, and it's just switch practitioners for technicians. Can you discuss that briefly? We've got the limited amount of time. but
Oh, gosh, there's so much to say. You know, there are really, we perceived three problems with the LLT scheme. One was the pushback we would get from this group, and we were able to get past that fairly quickly. Another one was concern for the protection of folks who may be going to a lawyer who isn't a whole lawyer, and their ability to recognize other issues. You know, Washington now has triple LTs who practice in family law, but family law often overlaps with trusts and estates or with property law, and can those folks see those issues? But what we ended up with, and what was really most compelling to me personally, is that there's no data. One of the things that Janet said to us early in our meetings is follow the data, go where the empirical evidence leads you. And this is just a brand new scheme. Washington is off now. They've been at it for months, not even a year. Other states are following behind. We think the pragmatic course is to allow other programs to generate data so that we can follow that data.
data that's been generated, there is more data talking about specialty certification. And Lynn, can you talk briefly about specialty certification and where that stands?
We, in the group that I participated in, we discussed specialty certification as one approach for assisting both consumers who were looking for lawyers, as well as assisting lawyers who wanted to establish a specialty and advertise it, and to do it in a pretty straightforward way. Our proposal focuses on education, a test, good standing in the bar, some setting of a minimum amount of experience as a lawyer, but basically it would allow, it would hopefully help provide one avenue in the marketplace for those in search of legal services to find lawyers who were interested in an area, took the time and effort to take additional courses of study, pass a test, and be focused on that practice area. And it would allow the lawyers, a lot of times traditional specialty programs, you sort of already have to be someone with a very extensive book of business and many years of experience in the specialty area to get any kind of traction to be able to advertise that you're a specialist. This would be a more open way to allow people who had interests in specialties to pursue them, to get them, to advertise them, and for the marketplace to be aware of these.
And that appears to be a significant difference between what Michigan is contemplating and what is currently available around the country. Are there other differences between what the recommendation may be and what you're seeing out in the market?
Well, what you see in a lot of states, most states have mandatory CLE for one thing, and we don't. So they have a whole administrative mechanism in place and many rules and regulations and storehouse of data about CLE credits and providers that are kind of at the foundation of their systems. And then they're a pretty exclusive club. There's usually a requirement that you already have and are practicing in the, usually a third of your cases are that. Sometimes there's a level of cases that you have to have. You need peer recommendations in the area. So you have to sort of already, over a long period of time, achieved the status de facto, and then you take continuing education and pass a test. And it's usually a pretty small percentage of lawyers in those states that do this. We were hoping that a system that was a little more direct of education, pass a test, be in good standing in the bar, would encourage lawyers to voluntarily pursue more education and focus on specialty areas, and not, without having the traditional MCLE system.
Yeah. Mm-hmm. One of the things I thought about, the difference between what we're talking about doing in Michigan, at least recommended, is it's a system that is open and objective and more likely to therefore result in diversity. if in fact you have the good old girl system, there must be one somewhere, it is going to, it tends to be more closed, and it ends up with the kind of problems that we had at one point in Michigan, even with our facilitative mediation. So if you have an objective bar that people have to reach, then you will have greater access, and even those specialties will be better able to address the diverse population of the state.
Now, there was a 4-letter acronym that was mentioned, MCLE, and whenever lawyers hear that, at least lawyers in Michigan, the hair on the back of the neck tends to stand up, and there's an automatic no vote. Just to be clear, the recommendations do not include mandatory continuing legal education. So for those of you who are already sharpening your knives, you can put them away, at least on that point. Moving on, one question for the whole panel is, as we're bringing this session to a close, was there one particular idea or one insight that came out of at least the preliminary recommendations that really caught your attention and excited you either positively or negatively that you'd like to discuss very briefly in the couple minutes we have left? I'll start. Chris, I haven't picked on you lately, so I'll start with Chris.
Gosh, you know, the rainbow is the great idea. This is like that scene in Animal House where Kevin Bacon is going through the hazing ritual, and he says, "Thank you, sir, may I have another?" That's kind of what our profession needs to go through right now. The one idea that came out that was totally off the wall that I thought was kind of cool was the idea of having unique and very focused specialty courts that were multi-venue courts. For instance, taking class action disputes and having a class action judge that practiced in different venues and was uniquely suited to those cases, so that when you have a class action case in someplace like Menominee County, you don't have a judge who says, "Gee, I've never had a class action case before, what do I do?" And what comes with that is the idea of centralized filing, such that those cases can be assigned from a central location, computerized centralized filing.
Angela.
I was very excited. We talked about the idea of a legal health checkup tool, and we talked about gamification and making some sort of really appealing game that people could play to learn about legal issues that they might not even know that they have. It would be a way to engage people in the law and help them address issues before they become real legal problems. So it could challenge them in an interesting game fashion so that they would be engaged and continue to be engaged and learn where they have weaknesses that might lead to legal problems and learn how to address them.
Lynn?
Well, I'm at the Institute of Continuing Legal Education, so it's really the education part that excited me, because the field of education, especially continuing education, combined with, again, technology that just allows delivery of some pretty terrific stuff now, means that whether it's the public, or lawyers, or other types of legal professionals, I think we're on the brink of just some fabulous systems of access to information, access to high quality, just-in-time training and education. And I think that many of the things in this report are tied in with those things, that we're really opening ourselves up to looking at what's going on in the whole field of education as well.
Your Honor, last word?
Except that I have to come back up here again. I'm intrigued by the idea of specialty courts, but on one hand intrigued but concerned. Why does something deserve a specialty court? Is that an inflexible or is it a rolling concept? And the idea that we should be able to respond to whatever specialty is needed, and what are the matrices that we look to choose that? And then, how do people come to serve on that specialty court? It seems to me that we should be as concerned about objective training and objective criteria and opportunity to train and therefore sit, rather than anointing.
Okay, we have reached our allotted time. I don't know if there are any questions from the other, or comments that the other panelists or audience might want to have. Okay, in that case, I will turn it over for the next session.